recording. So my name is Chris. I'll be your chair for this round. Congratulations for making it to the quarters. A round for applause for everyone. I don't have my camera on, but I am clapping right now. I guarantee that. We'll not go around, and you can give us your speaking order and your preferred pronouns right after I get my panelists to introduce themselves first and offer any pronouns if you'd like to do so.
Hi everyone, my name is Mashaya. My pronouns are he, him, and best of luck.
Hi everybody, my name is Adipat. I'm your panel for this round. My preferred gender pronouns are he, they. All the best for the round.
Okay, perfect. Yeah, please address the panel as a whole if you'd like to do so in your speeches. But at this point, we can go ahead and get introductions and streaming consent, starting with OG.
Gwyl, speaking first, no preference. I am okay with being streamed.
Emily second, she, they, please. I am fine with being streamed.
Thank you. No opening opposition.
I'm Inseo, Choi. My pronouns are she, hers. We're also okay with streaming.
And I'm Lelan, who I'm going second, and my pronouns are also she, hers, and I also consent to streaming.
Perfect. And closing government?
Hi, I'm Namita. I'm going first. I have no preference, and I consent to streaming.
Lucía, whip, she, streaming is fine.
Thank you. And in closing opposition?
Hi there, Alex speaking first, prefer he or they, and I do not consent to streaming or recording.
Sorry, Sajid speaking second, he or they, please. I'm okay with being streamed.
Okay, perfect. That's all. Thanks a lot, everyone. Speeches are sevens, of course. I'll be doing times for you in chat. Let me get my timer up. If you have a preferred way to take POIs, of course, do mention it before your speech. But at this point, I'd like to call on the Prime Minister to introduce the motion, stands her name. Here.
Okay, cool. Just checking that I am still audible.
Yes.
Cool. I will try and take POI from closing opposition by 5 minutes. If I've not done so by then, please unmute yourselves and offer it because I've just missed it in the chat. Cool. Starting speech in 3, 2, 1. Okay, so first part of the speech is just going to be a definition of what exactly we mean by this. Secondly, some framing about why this is unlikely to be used frivolously, and also what the situation is with not guilty verdicts on status quo, double jeopardy rules, and mistrial stuff. Then actually onto what this means. Okay, in terms of definition, I think just by supports we mean that we prefer the counterfactual world in which this is an aspect of more legal systems than it is currently. I think that's fairly clear. If anyone has any issues with that, they can offer clarification at 1 minute. Okay, cool. Let's go straight on to framing. First thing to note is we think that juries on status quo have a lot of pressures that lead them to be decisive. Which means that we think that given that they have a preference towards being decisive, it's unlikely that they're going to use these not proven verdicts frivolously. It is likely that they are overwhelmingly used in cases of where there is genuinely insufficient evidence to convict, right? Why is it we think juries are so decisive on status quo? First thing to note is that there are jury selection processes whereby both the prosecution and the defense get to effectively curate who the jury is, which means that they are likely to cut down on the extreme extreme views, people who they think are more likely to disagree with them. That leads to a trend towards selection for people with very similar views, very centrist views in terms of how they expect them to vote. What this means is that these groups are especially vulnerable to groupthink, effectively because there is often a lack of dissenting voices. A lack of dissenting voices leads to a perception that a decision often has that you should have greater confidence in this decision because there is like nobody telling you why it is that maybe you are making that you are over reading into like the extent to which this evidence supports this claim, right? But secondly, we also think that like jurors just generally feel like they have a moral and civic duty to be decisive because like criminal cases are high stakes and we have like societal narratives around the idea that criminals are bad people who deserve to be punished and innocent people are good and should not be punished, which means that I think that that people very much want to decisively say these are bad people, we need to lock them up, we don't want them getting away with it, right? Second thing to note is that like on status quo, you basically have the options of guilty and not guilty. Note that if you are found not guilty, you cannot be tried again for the same crime under like no double jeopardy rules, which effectively means even if like new evidence comes to light, right? Which means that the only way that exists on status quo for like changing verdicts is through like mistrials, right? The problem with mistrials is that it's generally not about a lack of, it's not about like a lack of sufficient evidence or new evidence coming to light, but rather that the original evidence that was used was in some way improperly handled. Maybe it was not shown to the defense's lawyers in time, maybe it was obtained through illegal means, etc. That very much narrows the range of cases in which you can get retrials, right? I think what this means is that on status quo, when there are cases where there is genuinely a lack of sufficient evidence either way, right? You are either, juries either are going to be convicting on this insufficient evidence or they are I think it is very unlikely that juries convict the exact amount, right amount of the time that they should be convicting here. I think it is either the case that they are that they are generally convicting on insufficient evidence, or that they are generally not convicting when they should be convicting, right? Because they don't want to send people to jail on insufficient evidence, right? Let's establish this, like why this first thing, convicting on insufficient evidence, is bad, right? I think just firstly at the point where you are like where you have a predilection towards convicting in cases of reasonable doubt, I think that you are more likely to convict more innocent people, subject them to the like horrors of the penal system than you should, right? I think you are much more likely to get a high false positive rate, which we think it is probably worse that innocent people are subjected to the penal system than that guilty people potentially walk free because of the just complete life-ruining effects that this system has. You are often subjected to violence and humiliation on every level. You are put in a position with dangerous individuals. You are like denied many of your freedoms for years of your life. I think this is terrible. But note also that this is often a burden that is disproportionately going to fall upon minority groups, which for whom, when there is insufficient clear evidence, subconscious bias is more likely to creep in to lead jurors to view this in a guilty manner. I will take CO now. Sorry.
Yeah, given that you have like a legal obligation to find people not guilty when there is not sufficient evidence to convict, why is this in any way likely?
Okay, cool. Right, but like the standard for what is sufficient evidence is somewhat arbitrary, given that like you can never be 100% sure of anything. And like, I don't even think that we work in specifically rigorous thresholds here, right? I think that there is definitely margin for error, and the people who suffer the most on that margin for error are people whose society devalues their voices on status quo, who views as more likely to be criminal because of like racist narratives about like African Americans, for example. I think that this not only is really bad for those individuals themselves, it is also really bad when this is like happening, even if it's the case that more people who committed crimes from those communities get convicted and sent to prison than of other groups. This is additionally bad because of like the effect it has in terms of over-policing effect, the effects it has in terms of like removing wealth, like providers from families and destroying communities like that. I think that's really bad. I also think it's often, yeah, sorry, sort of run out of time. Emily will cover the remaining stuff.
I'd like to thank the Prime Minister for the final remarks, and I'd like to call on the Leader of the Opposition to introduce the case for the opposition bench. Here.
Am I audible?
Yeah, I can hear you.
We're going to prove to you why the government case worsens all criminal trials in all respects. And before moving on to that, let's refute. So they said just a few things, like how juries are pressurized to be decisive. A, this is an unwarranted assertion, and B, this is irrelevant since this type of like groupthink pressure is inherent to all group activities. They don't prove why it's so significant in today's debate. And they also talk about how mistrials currently are just dismissed. This is simply not true because A, if there's a lack of evidence, or if the lines are very blurry when it comes to like making a justified verdict, they often appeal. It goes to like higher courts, such as the Supreme Court, if the case, like the lines are blurry. Or secondly, if there's just a tangible lack of evidence, it's likely that if the case is high profile, there's going to be a team dedicated to investigation assembled in order to progress. And they also asserted that this model would lead to like the current model leads to more convictions of innocent individuals. A, this is also structurally unwarranted due to the current principle of innocent until proven guilty. In the status quo, when there's insufficient evidence, court cases are dismissed. And we think that this type of like extra conviction or type of extra penalties even worsened under their model. We're going to prove you this. And secondly, if you want to talk about mass incarceration problems of these states, you should rectify this using different means. This is a different debate, like scrutinizing the court against leniency towards white police officers. They never prove how they specifically solved this. So having this cleaned up, let's move on to the first argument about how their case fails to attain, how this third option fails to attain the main pillars of criminal justice. So let's divide this into scenarios. A, when the defendant is actually guilty. So when this third option is resorted, we think that when it comes to rehabilitation, deterrence, and retribution, there's no functional benefit in all three levels because this third option is just a symbolic gesture which does not provide any proportionate retribution towards the crimes committed. And also remember that this is a criminal case which actually involves the damage of another human being. So let's establish what happens in the status quo and the comparative. We think that if the jury believes that the defendant is guilty but lacks evidence, in the status quo, the case is opened up to second trial after sufficient collection of evidence, which teams of police and relevant personnel are cued to comprehensively investigate the case, which is very true to high-profile cases of sexual assault or kidnapping. In South Korea, there has been a case that have been prolonged for very long in order to attain the necessary evidence, like piece together all the puzzle pieces and come to a comprehensive verdict. So we think that these types of collective efforts are less likely to happen because this is such a much more of a convenient option. Secondly, the second scenario when the defendant is actually innocent. We think that the current dictum of innocent until proven guilty, which is very necessary for the state force and the state's legal system to not be unjustly applied to individuals, would be meaningless because we think that if there's insufficient evidence, even after prolonged investigation, in the status quo, the case is dismissed. But now, as this third option exists, we think that this is very likely to be abused under certain specific contexts. We're going to flip their argument on their heads and talk about like the entrenched biases in juries. We think that when it comes to especially racial or religious minorities in contexts such as like Muslims in India or religious minorities in Myanmar or Uyghurs in China, we think that those individuals that are minorities are already less less trusted by the jury. And juries, as an average individuals, which are just like randomly picked from like the group listings, are more likely to perceive them as suspicious and potential criminals due to like active state propaganda. And we think that this will manifest in a decision of this like bad mark of you being seen as suspicious being disproportionately applied to certain minorities and politically abused for minority populations that are already structurally oppressed by the state. And when the state wants to charge them criminally, but in the status quo, they currently don't have like the legal justification or the warrant to clearly charge them. But now we think that this type of very blurry line of this third option being existent is likely that they're going to charge them like unduly and engrave this type of scarlet letter-ish criminal record of like a bad mark within their history. We think that this itself is extremely hazardous because it creates like an inability to rehabilitate because you have like a bad mark of this option being stamped in your criminal record. And in the status quo, this is not happening because there's no sufficient legal justification to call you for criminal charges and even resort to this third option of you like being judged as suspicious and potentially guilty. So we think that this type of blurry lines is extremely harmful to minorities within structurally oppressed societies. Let's move on to the second impact of sexual harassment and assault cases. We think that jurors are more likely to opt into this third option rather than choosing a harder stance and like attaining sufficient evidence. We think that in government, jurors are likely to choose not proven despite thinking that the defendant is likely guilty because of the false conceptions of evidence and whether they mean that the assault actually occurred or not due to like the very hazy nature of sexual assault cases in most of the cases because it's very heavily dependent on testimony. So we think that this is especially true due to the different weighing of victims' testimony and due to like one's internal biases, you might think that the victim's response was right or not right. And we think that the evidence is usually very fine and subtle, and they could prove evidence of something occurring, but not necessarily like a lack of consent or whatnot. So we think that also structurally, the impact of a single guilty case is more impactful than many cases of innocent verdicts. And since they just need one landmark case when it comes to like courtroom establishment, it's likely that they're not going to consider such individual sexual harassment cases as deeply because they could just choose this very convenient option that has the facade of a nuanced approach of you being suspicious, potentially guilty, but not facing any of the actual functional criminal charges. So this is likely to like brush away a lot of sexual harassment cases, which could be potentially open to like additional investigation and public discourse. So this is a wasted opportunity. And lastly, this is going to be abused and misused as a convenient option to functionally dismiss the case because it's expedient for the courtroom to resort to this option because A, it's time consuming to gather admissible evidence, gather testimonies, like garner like different pieces. And secondly, it exempts all the people, like especially prosecutors and attorneys from the moral burden and the guilt of letting a perpetrator free because at least they make the attempt. But functionally, remember, they're not guilty and there's no retribution whatsoever. And thirdly, generally, there'll be less workload like levied on the shoulders of like prosecutors because functionally does the same as dismissal. They don't have to care about the technical steps of implementing the punishment. So it's likely the impact is how this third option is going to be applied more frequently, and there's going to be an unspoken rule pressurizing juries to choose this option. And the courtroom dynamics pressurizing them because this is more convenient for everyone and all the others in the courtroom. It's likely to be them to be complacent and not be put to the highest standards of justice, and prosecutors not fulfilling the burden of proof because they have this very expedient third option. Due to these reasons, extremely happy to oppose.
I'd like to thank the leader of the opposition for their fine remarks. I'd now like to call on the Deputy Prime Minister to continue the case for going bench.
Okay, I'm just going to open my window. Can I check that you can hear me?
Yeah.
Great. Okay. 3, 2, I'm not sure when direct rebuttal and actual engagement went out of vogue, but I think it is an absolute tragedy for modern debating. What I'm going to do is several things. Firstly, directly rebut and engage with opening opposition's case, a generosity they did not provide to us. Secondly, deal with legal obligations and ways in which juries interact. And then secondly, walk you through the decision tree of the cases that matter here, which is when you are not guilty, but and you end up going to prison anyway, or when you are guilty and therefore your victim is harmed when you are not prosecuted. And at least now they have the levity of a not proven case. So what do we get from the opening opposition? I think we get up to, let's say, 6 assertions. Firstly, the idea that groupthink is not significant or is an assertion within our case. Look, calling something an assertion doesn't mean Gwyl's analysis didn't happen. Judges are entirely capable of checking your notes, check your flow, please rebut it next time. I think there are lots of reasons why groupthink isn't necessarily inevitable, because you have moral enforcers who rampage through society, who think crime is an absolute issue, who are oftentimes selected on either side of the jury because they are likely to rigorously look over or consider circumstance, because they're the people who want to be on juries because they feel like they're placing some part in civic duty, so they don't do things that get them thrown out of courts, etc., which means they are overwhelmingly likely to sit on a panel, which means that they are overwhelmingly likely to tend towards their kind of conviction narratives, etc. Secondly, in terms of things being blurry or not guilty leading necessarily to a retrial, we think there are different evidentiary standards or processes for how different courts deal with things. In some cases, a mistrial will lead to you certainly going back and re-prosecuting that case. In some situations, not guilty will mean that you do not reopen that case unless there is significant new evidence, which there is unlikely to be because we have no reason to believe that once you are proven not guilty, you continue to dog a case and go after it. Their response to this, or the way in which they build this up, is, but high-profile cases end up meaning that more engagement happens. Yeah, more high-profile cases will have more engagement, but there are so many crimes committed every day that you just will not ever hear about. No one cares about people being raped at parties if someone got raped on a high-profile college campus. I'm just not sure that those victims don't matter within this situation, and insofar as your case only has solvency for the bare minimum of situations, I'm just not sure why it particularly matters. I think I'm going to deal with the guilty and now not proven stuff within the main body of my argumentation, etc. The last thing that we kind of get from here that I think could generously be called a substantive case is the idea that it is expedient to throw out large portions of crimes, etc. I think for their own reasoning, this is unlikely to happen because everyone who is a prosecutor or a defender or a judge or cares about being on a jury, cares about crimes, will be dogged by the idea that there is a criminal they chose not to prosecute who is now gone out and harmed more people in the process. I think lenience ultimately is a political sin and is something that no one will actually want to buy into. Cool. So why do you have, let's deal now with CO's POI to us. Oh, you have a legal obligation to find someone not guilty. Look, I have legal obligations not to steal glasses from pubs. My house is fucking full of them. I just don't think that that actually meaningfully matters. Laws ultimately are about how you relate to and place yourself versus those laws. So if it is redundant that a overly prosecutorial society thinks it is your obligation to go ahead and to lock up people who you think are overwhelmingly likely to be guilty regardless of the circumstance, then it is your duty as a state to implement new sets of legislature that mean that they are less likely to do that. How is that necessarily likely to happen? Let's talk about those who aren't guilty, who are overwhelmingly harmed. Luckily, opening opposition has done a large portion of this analysis for us, and what they failed to acknowledge, though, is in a situation wherein you overwhelmingly presume guilt through things like Uyghur Muslims or like minorities within your society, etc., then that ultimately leads to a significant portion of harms. Why we don't think this case is a huge shift or a huge change, but if there are just enough people with cracks in their ideas of how circumstantial evidence is weighed up, who think perhaps beyond reasonable doubt now means that we have to consider whether this white woman is, maybe saying falsehoods about black men, that there is conjecture or weak standards, and you have a lawyer being able to push for not proven, saying that the victim isn't necessarily lying, but you just don't have enough to go on, so you shouldn't go on, then that ultimately means that there is a huge shift when you multiply this across out how racist societies are overall, in the numbers of minorities who are not guilty, who now don't go to prison, because in that society, they do, on their comparative, they do go to prison. They lose their connections to their families, to their communities, to their ability to make work. They are tarred as morally degraded and oftentimes seen as beyond the pale. Their comparative shift in freedom is both a psychological one on our side, wherein you are not locked in a box for the rest of time, undogged by the idea that everyone believes that you are guilty and you are beyond reproach or any kind of recompense in society, which oftentimes makes you feel much worse overall. That is a really big benefit on our side of the house in the case that we get significantly more not provens. Victims, yeah, then they're going to have a shitty time because the police have picked the wrong person to prosecute and therefore cannot go out for them. But on either side of the house, we're just not sure why victims getting some sense of safety or retribution or rehabilitation, if it is the wrong person, is just. The state has obligations to the innocent as well. We think you shouldn't harm them, therefore. Let's interact with CO. Nothing? Okay.
Hello. So if juries are as decisive as you claim, why will they not just pick the two options that were already traditionally available to them and go for this third option by your own analysis?
So it sounds like on our side of the house, the worst case scenario you've built up for us is your side of the house. I just don't think that is a meaningful line of opposition to our argumentation. But equally, let's point out that when you have that nudge where you are necessarily have to turn around and think about, is this enough of an evidentiary standard? Is this person really not guilty? Do I feel bad about sending this white man to prison? Or do I think that black people belong in prison because I'm a racist scumbag and a moral enforcer? That now cracks it just enough that we think you get a marginal shift. This is not the end of the world and it's not going to change every injustice in a system, but it will make things much better. How does this help victims? I think oftentimes there's nothing worse than a victim actually going forwards, telling the police that you've been raped, doing a rape kit, having to talk about all the ways that someone was awful to you, and then having a jury turn around and say, but we think you wanted it though, or we think that you would have meaningfully consented to this act because the person you are having sex with is someone we think people would meaningfully consent into having sex with. I think that means you get dogged in the press, you are tarred as a liar, you are tarred as ruining someone's life, and I think that means that you are tarred as frivolously mistruthful and ultimately just knocked out of all semblance of like being meaningfully trusted in your life. I think a not proven is just enough as a victim to hold on that, you know what, we have poor evidentiary standards, they're necessary for other crimes, but now someone listened to you and thinks that it might have happened. Thanks.
I'd like to thank the Deputy Prime Minister for those final remarks. I'd like to call on the Deputy of the Opposition to continue the case for the opposition bench. Thank you.
Okay, just to check the audio works.
Yes, I can hear you.
All right, wonderful. I think there's a reason why Scotland is the only region in the world that has this policy, because it's just blatantly a terrible idea. I'll talk about two main clashes in this debate. Firstly, on the general case in terms of how generally juries as well as court systems respond to this. Secondly, in terms of sexual harassment and assault, of which we got little response except for just how bad it might be for victims. Firstly, on the general case, right? So all rebuttals will be integrated. OG says here that there is pressure to be decisive because of two reasons. Firstly, in jury selection, you want people with similar or centrist views, and they will all be decisive because of groupthink. And secondly, because most jurors feel a duty to be decisive and to serve justice because it's such a high stakes situation. Both of these are incorrect. Firstly, on jury selection, because jury selection is firstly about how involved you are in the trial, whether you have other interests, whether you may be a relative of someone who is involved, whether you may have friends or have certain political leanings that is too extreme. There is no personality test to ensure that you are decisive or not. And if there is, it's probably problematic for a lot of reasons regarding sexism and discriminatory reasons. We think this is just does not exist in the jury selection. We don't think this is a good reason for why it occurs. But secondly, even if you do have this kind of people who are centrist and moderate are put into juries, people are still likely going to be cautious about decisions, right? If anything, centrism and moderation just means that you're likely to be cautious, to be moderate in terms of how you consider evidence, and to be moderate about your decision, unlikely to be really hard, unlikely to go hardline on a particular decision. Secondly, the reason they provide is just like you feel a duty to be decisive and to serve justice because of how high stakes each criminal case is. The problem with this is that firstly, it is high stakes, so that that's why most people are cautious about giving someone a guilty verdict and putting them in prison. You're scared of destroying someone's life in the same way that OG does not want to destroy innocent people's life, or nor that anyone in this room probably does not want to destroy an innocent person's life. And this means that even if it is probable that they committed a crime, you're still unlikely to put them inside prison, unlikely to give them a guilty verdict because you're scared of the implications of this. It will hang on you like a moral cloud for the rest of your life. Secondly, yes, like sure, we agree with the OG that you want to serve justice. You think that criminals are, quote, bad people according to PM, but the problem is that the logic is just inverted, right? You're not even sure that they are bad people in the first place. It does not apply to the trial process where you're deciding whether or not they are a criminal in the first place. We don't think this applies in the first case, in this case at all. And third reason is that jurors often do not want to be the person pushing for a guilty verdict inside the room where jurors like talk to each other, because most people are comfortable with giving them a not guilty because of how high stakes it is. We think this is unlikely that a person will stand out and say, I think they are very guilty. We think this is where it's more likely that it's going to hang on another person's conscience, and they're likely to choose a more expedient option. Also some additional reasons that also Inseo already told you about why our jurors are likely to choose this as an easy way out. First thing is that jurors are also just human. They have little incentive to view everything that happens in the courtroom with rigor all of the time, right? And the reason that this is the case is because there's no check on juries deciding too quickly, or individual jurors thinking things through not too clearly. Like juries decide by themselves in their own room. So that's why you don't see on the news this person as a juror is a poor decision maker. You don't have this kind of feedback system or check and balance system that ensure we have good decisions all the time. And the reason why they're unlikely to view everything with logical rigor all the time is because trials are exhaustingly long. Firstly, it just takes a long time in general. And two, trials also present a lot of different complex pieces of evidence that interact in different ways. As an analogy, it's basically an extremely long and very messy debate, right? It's obviously a lot easier for you to just say, well, everyone loses in this round, or it is a tie between 2 teams or 3 teams, than it is to actually give a verdict. We think this is where it's more likely that individual people who likely have other things going on in their lives, as well as have limited capacities to handle very complex issues like all human beings do. Also, how just like there are issues of not only how these pieces of evidence interact, but whether these pieces of evidence even prove something, or whether someone is lying, or whether telling the truth. You can't even Google whether or not someone is lying in a basic IR round, because it's not basic facts. They're issues that are difficult for you to contemplate. That is why it is much easier and a much lower of a moral burden to prosecute them, but without the actual effects of prosecution by giving them a not guilty verdict. So the conclusion is that much of government's case hangs on the assumption that everyone in the courtroom is full of energy to analyze evidence and is oriented for perfect justice, which is untrue. OG also says you're more likely to put innocent people in prison, but the problem is that not guilty as a verdict is basically widely believed, and jurors are part of the people who widely believe this, to mean that you are probably guilty, but there may be insufficient evidence to prove this. So we think it is unlikely that someone who is innocent is just going to be put in prison because of this. It's more likely they were probably guilty in the first place. It's just that you couldn't find the specific, you didn't feel like you wanted to have the moral burden of putting them in prison. OG also says different things about ethnicities and discrimination, but the problem is that one, this is the same for victims. It's probably even worse for the victims of a minority race, because they're likely to have actually suffered from crimes as victims. They're not the people who are being prosecuted, but the people who are reporting these crimes. It took a lot of courage to go into the court system, etc., etc. It's probably worse for them in this case. Secondly, where is it different between victims and like people being people who are defendants being racial or ethnic or gender minorities? It's because when you talk about racial minorities, it's not about whether they are guilty. You probably have the inclination to feel that they are guilty on either side of the house. It is about over-sentencing, and over-sentencing is not something that jurors do. It's what the judge does. And before 6, I'll take CG.
Yeah, look, your claim is that minorities are going to get affected disproportionately. This is likely to happen on both sides. Surely then this debate is about increasing suspicion and why that's something we should care about.
Obviously, I think we already told you that why increasing suspicion is something that is dealt with out of this debate. It's all about policies about discrimination that we probably can't solve on either side of the house. But it's just worse for victims in general if the victim is the ethnic minority, because they likely suffer from a previous crime. So you're imposing a second crime on them, not just that people view them with suspicion. But lastly, on sexual harassment and assault, though basically the only thing we hear from OG is just because that it's worse if people get an innocent verdict. The problem is that one, people already understand that these crimes are likely to be declared as, these criminals are likely to be declared as innocent because how difficult it is to prove that sexual assault or harassment occurred in the first place. The general atmosphere after the Me Too movement, all these different cases. That's why the person from, I believe, the case 2 years ago was extremely angry when she got a not guilty verdict instead of something else, because it just goes to show how jurors are likely to opt for this instead of choosing a harder stance. And this is just ever more likely to disproportionately happen in sexual assault cases, just because people who are jurors are likely to have bad conceptions of what it means to go through sexual assault. So they don't view the victim's testimony or the responses as evidence that proves that this assault did occur. Evidence in sexual assault cases are also used just very fine and very subtle. It's very hard to prove the lack of consent occurred. These are all reasons why it is likely for jurors, even though they think the person who is powerful and who have the past history might have committed this act, but they don't think that the evidence is sufficient to prove it, even when it probably is, and it's just due to their own suspicions and their own lack of knowledge about a sexual assault case, they decided to choose not guilty. And for all these reasons, we're very proud to oppose.
I'd like to thank the Deputy Leader of the Opposition for the final remarks, and I'd like to call on the Member of Government to extend the case for the government bench. Here.
Can I be heard?
Yes, I can hear you.
All right, there's some construction going on, so if at any point you want me to speak louder, please let me know. I'm just going to start off my timer and then begin. Whoever wants to ask me a POI, please put it in the chat. If I haven't taken you by 5:30-ish, you can feel free to unmute yourself and ask me. Great. Starting in 3, 2, 1. Panel, the fundamental goal of the justice system is, yes, to protect individuals from harm, which is why we think punishment is viewed as a harm. This is the reason why the innocent until proven guilty is considered to be the bare minimum standard in society. Conversely, however, I think it's equally important that individuals against whom harm is committed is protected. And this is the unique way in which you're able to ensure this by the presence of the third thing. Before I jump into extension, I have 2 responses to opening opposition. First, on why their alternatives of appellate systems doesn't really work. 1, I do not think victims have the resources to apply to appellate jurisdiction because it takes a lot of money. But secondly, it's just very time consuming. And you probably don't want to go through that entire trauma again, where another jury is likely to tell you that, no, you're wrong. I don't think these people are willing to make the trade-off of maybe, just maybe I might get a better verdict. It doesn't happen. Secondly, higher courts are even less likely to care about inverting verdicts when there is a gray area, because it seems like the rest of the the rest of the judiciary system is now incompetent for giving a bad verdict earlier. This just gives a bad reputation on them. And most of them will be gray area verdicts because obvious cases can be called out by the media. Secondly, I think opening opposition's claims that this disproportionately affects minorities, they did not respond to my POI well. I think it is extremely rare that minorities are going to be viewed as innocent. Even if they are, society doesn't treat them so. I think this debate then is about those instances where innocence allows white men to get away with crimes when they literally look like, I don't know, a blonde person that everyone probably wants to have sex with. 2 extensions then primarily. Firstly, on why this creates a balance in the judicial system, and secondly, why overall suspicion is good just in terms of the interaction that we have. Firstly, on balance of systems. Context, why is the system currently unbalanced? For 2 reasons. I think the first claim is that the narrative that you have to prove a crime beyond a reasonable doubt essentially means that even if there is a smallest sliver of doubt, which is to say, maybe he does it even 1%, absolutely disregards anything that the prosecution would have gotten, and essentially means that you have to give a blanket not guilty verdict. Secondly, I think states and prosecutors are just severely underfunded, because of which they aren't able to carry out investigations to the best degree, which means they probably aren't able to get out evidence to the best degree. I think the combination of both of these explanations makes it next to impossible for prosecutors to carry out fair techniques and actually prepare like a fair presentation or a fair challenge in the case of the victim. I think, but even if you don't believe that, right? I think thirdly, juries are likely to be biased on presentation and the language itself used. For example, in a sexual assault case, making a man dress up really well and using language such as "she tried to come on me" and literally playing the blame game, etc., already prey on existing societal balances that dictate women are inferior and that dictate they must submit to men and things like that. Note that this goes beyond opening government's explanation, who claims that people in juries may or may not be biased, but we significantly tell you why the legal system and the construction of the legal system exploits this even more. We think this is also invulnerable to whether or not people are perfect, that OO contest, simply because this is a issue of funding and an issue of the way that we perceive the judicial system in a philosophy context. why does this get better on our side then in terms of balancing a system? And this leads to my second extension on why suspicion is good. I think essentially when you create the binary of guilty and non-guilty, you make it extremely invulnerable for the person who has been acquitted in a non-guilty verdict to now come and say that this person can ever do something wrong. Why is overall suspicion good in that extent? Because I think to the extent where we agree that mistrials are bad for a couple of reasons, I think first, as OG outlines, obviously it's going to be incredibly difficult for you to get new material. But I just think secondly, the point at which there has been a mistrial, there is already significant doubt cast on the competence of the people participating in that trial. I think given that juries are ultimately humans, they see that there might be some degree of incompetence that you couldn't possibly resolve, and therefore are just uninclined to give a good verdict in itself. This is how they interact with them, which means that the only way for you to resolve existing biases within society is to ensure that once a person does not go to jail, because he's unlikely to go to jail because, I don't know, people who are white, people who look fancy can probably get away with sexual assault because they have a lot of resources to do so. Regardless, why is overall suspicion to that extent good? One, I think in the absence of suspicion existing within society, which is to say a not proven verdict, in the absence of this, when a rich man is acquitted and labeled not guilty, I think he is protected and his character is protected because the inverse of that would seem like an assault on their character. Hence, even if a new crime is committed now, you go like, look, he has been given a not guilty verdict before, surely he can't do that. The converse of this is like suspicion that's raised, which is to say, last time there wasn't any evidence, but it's left sort of a loose thing, which means I'm probably inclined to believe that this person is a shitty character. This can only happen in a not proven aspect when there is a possibility of people interacting with the perception that, yes, this person must have done something wrong. Secondly, a not innocent thing just brazenly gives them out jobs, blah, blah, blah. I think at this point where you have the not proven verdict, at least employers and people interacting with them will be hesitant in interacting with them or abjectly glorifying them on our side. This engages with opening opposition's material, because the reason that you make a victim feel like shit is when when absolute innocence of a person that has done harm to them is proven. If a degree of suspicion exists, I think that is still better on our side of the house. I will take closing at this point if they have anything. Okay, opening.
When you're talking about high-profile cases with powerful men, currently they're open to more comprehensive investigation, like the Harvey Weinstein case. Under your world, it's more likely that they're just going to resort to this third option without publicizing this.
I don't think that's true, right? Look, I think even if there is a high degree of investigation, I just think the barrier for you, or the threshold for which the prosecution has to prove a certain thing, keeps on going higher. To the extent where that is true, to the extent where you can go like, maybe Harvey Weinstein didn't do it. And note that my previous explanation of the state just having really bad funding also essentially means that Harvey Weinstein, who's a private person, literally has the best lawyers in the world, but who can also can use language that spins the narrative in the favor of the man, essentially means that no matter how high profile a case is, it's always going to be a not guilty verdict. What do we get in, like, lastly, on like how legal systems change, I think you just acknowledge the fact that there is a lack in resources. And I think this is good, because in the absence of this, you view a not guilty verdict as an incompetency, as just an incompetency of the prosecutor, as opposed to they have severe issues in their system. I think at the end of this, what you need to take away is, one, how do we get just better interactions with people amongst society for people who are probably evil? Very, very proud to stand in proposition.
I'd like to thank the member of government for that fine speech. I'd like to call on the member of opposition to extend the case for the opposition bench. Here. Call on the government whip to conclude the case for the government bench. Here.
Cool. Am I audible?
Yeah.
All right, amazing. Starting in 3, 2, 1. Namita tells you that there is a crack in the justice system. Although we do believe that it is bad to put an innocent behind bars, we tell you that it's equally as bad to let guilty people walk free, and that the current system skews heavily against that. or heavily in favor of that. We believe that a not proven verdict actually balances the justice system and allows us to take into account the interests of both the guilty and the innocent. Two things that I'm going to be talking about quite biblically. I'm going to first talk about innocent people, second about guilty individuals. But before that, I just want to do some framing in terms of what matters in this debate. I think beyond the pillars of justice that we memorize to do well in debates like retribution, rehabilitation, victims' rights, the fundamental idea behind the justice system is that you should get the verdict that you deserve, guilty or innocent. And we think that this is going to make that more likely. We're very agnostic about the top half clash regarding about how it's going to influence juries or judges. We think that the most important thing is that there needs to be avenues within the system that people can utilize to get the best conviction possible. We can't control how people behave, but we can control the rules that they play by, and that's the most important thing. Let's get on to our first thing, the innocent. I want to deal with opening opposition directly here. When they tell you that minorities are going to get this instead of getting innocent like they should, it's going to overwhelmingly used against them. I want to first note that this is in huge tension with the vast majority of their case, where they tell you that juries and lawyers are going to go for not proven rather than for guilty. So I think that it's really unclear why it is that just because someone is brown, suddenly you don't want to do it anymore. I think my actual response is that, look, even if it happens, I think that's still better than getting a guilty one, which would have happened in the counterfactual. I think that the reason why this is true is because, you know, if the jury is really, really biased and genuinely believes that you did it, they're likely going to find evidence to convict you. I think that at least it's better if you get off with not proven, because that means that you don't have to go to jail and face immense amounts of punishment and time there. And I think that that's good, right? I think that the second thing, and I do think that and I think that the important thing is that also it's very unlikely that they're going to continue dragging you through the mud, because even if the jury is biased against you, there's still not enough evidence to convict you. So their investigation is unlikely to be reopened and you're unlikely to get a second trial. I also think that what Emily says is actually kind of true, which is it's probably not very high profile, so not really on the top of the to-do list for any lawyer anyway, given that there's many, many trials that happen every single day. So I think that if anything, this shows that it's better why, brown people everywhere get not proven rather than guilty, go to prison. I think that the more important thing though, is that overall, there are a lot of existing protections for people who are innocent within the system. And those protections look like you can prove that the jury is biased against you if someone appears to also be on an outright Facebook white nationalist group and therefore get a mistrial and get a second trial. You can fight the verdict if you were convicted and the state gives you lawyers in order to facilitate that. You can limit the punishment that an individual gets depending on the crime that they get. Juries can't just do whatever they want. But also the bar for what is and isn't criminal is incredibly high. And very frequently, there's even things that hamper the ability of the prosecution to function. Things such as if you find new evidence halfway through the trial, it doesn't matter because you didn't present it in the preliminary hearings, and that disadvantages the defendant. We automatically prioritize protecting an individual's innocence in a way that means that in many ways we do protect the innocent, but also it disadvantages prosecutions. Namita tells you that that's really bad. So let's not talk about the guilty. Overall, let's deal again with opening opposition, when they say, they're not going to prosecute high-profile cases. And I think that CG to an CEO also extend on this and talk about how it is that, the faith in the judicial system is going to be destroyed when individuals that are high-profile are no longer going to be convicted. I think I have two responses to this. Firstly, it is that if those individuals aren't prosecuted to guilty verdicts, then that means that there is a failure in the justice system. And it is important that this highlights it so we can address it, such as how in recent days, or in recent years rather, we have seen changes in the way that lawyers deal with sexual assault cases and how questions and protections for victims are a lot more thought about than they were before when you were just asked horrible things all the time. My second response is that I don't actually think this is true. There are huge incentives for you to convict Harvey Weinstein. The lawyer, like Cyrus Vance, the lawyer that prosecuted him, is now set for life, right? Because he has the most high-profile case ever in his career. There are huge incentives for individuals to go for convictions because that's what makes their career. The fact that I am a very good prosecution attorney, I win cases. You don't want to be the lawyer that had all the tools on the table to beat Harvey Weinstein and put him in jail, and that still failed to get a guilty verdict? You want to be the man that put him behind bars, right? And I think that's important. And I don't really think that they deal with that and why it is that people are going to be lazy in this way. I think the important thing is that even if judges or juries choose to dismiss it, you can still try for another time, rather than in the status quo where if you get not guilty, then you can't ever prosecute for the crime. I'm going to take opening opposition now.
As you said, if this option will be like frequently used under the case of like underfunded, overburdened prosecution, it's likely that they're going to just complacently choose this third option no matter what, because this has the guise of a nuanced verdict, but doesn't result.
I really don't think that it is, because I think that to individuals, or rather to society as a whole, when you get not proven, it wasn't proven, but that person's still walking outside in the streets, so they're still concerned for their safety. So I don't really think that people are, that, you know, if governments decide to just use this option, the population at large will be okay with it. And also, I don't think that lawyers, again, are going to want to do that, given that the way that they advance in their careers is by showing that they're very fucking good at putting people in prison. I want to deal then with sort of overall what Namita tells you, right? Is that I think that at the end of the day, there's, as I dealt with before, multiple ways embedded in the system for innocent people to get off. I don't think that there's that many for us to guarantee that guilty people won't walk off scot-free. I think CEO says, aha, it is illegitimate. People should always be innocent. But I think that this relies on a status quo bias, that we believe that putting innocent people is the worst thing that can happen. I want to posit that it's actually also bad if we put guilty people outside on the street for three reasons. Firstly, as OG says, victims, but more importantly, because it can potentially lead to further victims if you put someone who committed a crime outside. But thirdly, it's because it also signals to society as a large that if you commit a crime, that crime is not important. It can be dismissed. You can't get off scot-free. That's partly why we treat rape so poorly, right? Because people don't think that it's something that's going to land you in prison, because most of the times it doesn't. And I think this is what Namita tells you, right? That we need existing mechanisms in the system when there's not enough evidence, but there might be later, for us to be able to trial people that were clearly guilty, we just didn't have enough to convict. We think that we fixed that system. We think the system's broken. We beg you to fix it. Vote CG.
I'd like to thank the government whip for its fine speech. I'd now like to call on the opposition whip to conclude the case for the opposition bench and indeed the debate as a whole. Hear, hear.
Hello, can you hear me?
Yeah.
Okay, I'll take POIs in the chat, please. I mean, just say POI in the chat. I think most of this debate has been very unclear on what it wants, right? So I think it's important to do some accurate analysis. I think rich people with money are more likely to get away with things in the in a criminal trial because they can afford better lawyers. The narrative is in their favor, etc. And innocent and marginalized people are supposed to get away with it. This is why the clash on top half is so weird, right? Like, and it's so unresolved, because they say things within the courtroom changes just because you add this extra option that may or may not be used. Whatever happens in the courtroom depends on the narratives outside, like the narratives of what a Black person is capable of that society runs, like the racist narratives that exist, and the resources that people have available, right? These narratives aren't being changed by adding this. You probably make these worse at the point where Alexander tells you that this only gets used very little, and when it gets used in high-profile cases. Therefore, with Alexander's case, you first of all get a reason why outside narratives might change, why good people who don't commit crimes or commit crimes out of necessity still get guilty verdicts, and rich people are able to get away with it or suffer worse under their side. We also mechanize opening opposition's claim that of these things happening, right? Through people having faith, losing faith in the justice system, not participating in it as much, through high-profile cases being skewed in bad ways, etc. I'll engage with each team in this debate. Firstly, CG, and then OG. What do we get out of CG? The first thing CG tell us is that the justice system is unbalanced because just having a guilty or non-guilty verdict means like lawyers need to involve foul play, etc., to do certain things. First of all, a huge part of this exists outside the courtrooms as well. But to the extent that it does exist within the courtroom, like the language stuff that they talk about in terms of which convinces juries still gets used, and the prosecution still exists, and there is still incentive for them to do foul play, right? As Alexander tells you as Alexander tells you, and we think it probably gets more unfair, right? It to the point where you have an extra option, and they have more ways to do foul play. They have more ways to do witness intimidation. They have more ways to do all of the other things, and this is probably used mostly by the richest in society to be able to get away with these things, right? Like, notice how people who commit crimes out of necessity, or people who haven't done anything that's really morally wrong, are likely to leave some evidence behind, which would always get them convicted as guilty. But people who are professional criminals, people who are very rich, are able to like hire the best lawyers, are able to pay themselves out of that evidence to get away with these things. But where Alexander's case comes into this is that he tells you about how, because of these high profile cases and seeing that the rich people continuously keep getting away with it, this skews the faith that the general people have in terms of like how this like no verdict works, right? Because it is firstly likely to be used very little, and when it is used, it is likely to be used in high-profile cases, and because of that, less people get involved with the justice system, right? They're less likely to show up as witnesses because they know their opinion doesn't matter. Less people who living in marginalized communities are going to report cases to the police because they lose faith in the police even more than they already have. The second thing the CG bring us, that suspicion isn't good. Suspicion is good, but notice how CG need to first resolve the top half clash in order to say that any of their cases will have effect in terms of which people go into prison and which people don't. But secondly, I don't think they can legitimately claim that it is okay for society to conduct justice upon you if the courtroom finds you not guilty. But I'm not really sure how their mechanism of suspicion really helps. Their mechanisms of suspicion don't affect rich people or don't affect the kinds of victims that they want to claim about. Even if marginally the lives of rich people are ruined because people they don't really care about think they're suspicious, they still live in big mansions. They still live in like all of those. They still have all of those resources and support that their lives aren't meaningfully affected. And victims probably don't care that people are suspicious of their assaulters, right? They probably care. They care more about justice done upon them. I'll take OG if they have anything.
Yeah, so you claim that you have reputational harms as your largest impact. If you're innocent, this is already better than prison. If you're guilty, enjoy your pariah status, and note that also the retrial that's likely to happen now when you otherwise would have gotten off means that the justice system is just more accurate.
So this brings in the stuff Alexander says, right? Like, and this I'll also come on to this when I talk about you later. But when in the pariah stuff that they talk about, right? Like the suspicion that CG want to bring affects people who are marginalized the most because they're the ones who are meaningfully affected by this suspicion of having not guilty on their or no verdict on their head. This is also what Alexander talks about significantly when he talks about how the lives of the poorest people and the most marginalized people are ruined the most because no verdict literally goes on their records. And at the point where we're not changing the narrative against them, they're the ones who get no verdict more than rich people do probably. And then because of that, it goes on their record, and their lives are significantly ruined more than the lives of rich people could meaningfully be. Coming on to opening government then. What do we get out of them? Like opening government, I think like their first analysis of why juries are very decisive first goes to show that juries are very decisive. This isn't likely to be used frivolously. Works kind of against them, right? Because if they're decisive and traditionally it is guilty or not guilty, they are likely to pick one of those at the point where we consider that their impacts don't stand. And when Alexander has shown you that the only case, this happens in very few cases, and the only cases where that happens, it's highly publicized and highly, and it's very high profile, it reinforces the idea that of like you losing faith in the justice system. They also, and I also don't think they significant, and I think they have some contradictions, right? First they say innocent people are more likely to get away, then they say guilty people are more likely to go into prison. I think they just need to pick one, and I don't think they resolve that contradiction. Oppose.
I'd like to thank the speaker for that fine speech, and everyone for it was a very interesting debate. We're now going to deliberate, which I do believe should happen on here. So at this point, you can go ahead and disconnect from the call.